Good morning and welcome to the Lunchtime Live, an employment law session. My name is Aaron Demerson and I'm the Commissioner representing employers at the Texas Workforce Commission, appointed by Governor Abbott in 2019. I'm privileged to represent the over 565,000 Texas employers and 2.6 million small businesses in our state. Now, there were over 4,500 confirmed registrants on this first session, and we appreciate your attendance. Hope you guys are all getting in okay, and we're ready to roll. Since March, we've been assisting our Texas employers during these unprecedented times by answering thousands of phone calls and email inquiries, as well as participating in a number of virtual town hall meetings all over the state. But due to the ongoing needs of our employers, we created Lunchtime Live, and we're happy to have you here today. This is a temporary solution until we're able to host our Texas conferences for employers again in person. And we're sure looking forward to getting out to those respective communities. This is the first of 7 sessions we'll hold this year. You can get those dates on the employer page of the TWC website, along with registration links in the next week. We're looking forward to this event and just excited that you're part of what we're doing here. So today, you'll hear from 2 of our employment law attorneys, Tommy Simmons and Melissa Chapa, who will present on 3 topics: wage and hour law, medical leave, and payroll tax. They will also take some time at the end of their presentations to answer some of your pre-submitted questions. Now, just a couple of housekeeping rules before we get started. If you experience any technical difficulties during this session, do not stress. We will be recording this session and we'll have it available on our website for you to review and share. CLE credit will not be available for these virtual sessions. Once we start back to in-person conferences, these credits will be offered as usual. And finally, sit back, relax, and enjoy these presentations. Our office is here for you, and we'll continue to be an essential resource as we move forward during these unprecedented times. Thank you for your investment in our state. Thank you for all that you're doing. And more importantly, thank you for your participation today. And so let's continue to make progress. Let's continue to make a difference. And let me turn it over to Tommy Simmons to get us kicked off and started. Tommy, it's all yours.
Hello. Thank you, Commissioner. Can everybody hear me? Okay, very good. I'm going to try to share my screen here. Hopefully it'll go off without a problem. Okay. There may be a problem. Is that visible to y'all?
Yes.
Okay. Let's see here. There we go. Can everybody see that? Okay. Well, here is the contact information for Commissioner Demerson's office, and we have an FAQ file that will be available on our website shortly after this conference, but I went ahead and included the address there for everybody in the middle of my contact information there, right after FAQs. The online address for our free book, the Texas Guidebook for Employers, is the 3rd line from the bottom. The 2nd line from the bottom is our web app address, and that will work on any mobile device. Our toll-free number is at the bottom left, and our general office phone number is at the bottom right, and we encourage calls and emails. Now, before I get into details on the more technical issues under wage and hour law, I'd like to cover a few fundamentals just to make sure that we're all on the same page. The main wage payment law for the United States, the federal law, is the Fair Labor Standards Act. That's been around since 1938, but it covers a few main things, one of which is minimum wage. The minimum wage is currently $7.25 per hour, and what that means is no matter what the pay method is, the employee's pay needs to equal at least $7.25 per hour for all hours actually worked. Overtime pay, the basic rule on overtime is that overtime is owed on any time worked in excess of 40 hours in a 7-day work week, and that's actual work. It's not paid leave or paid holidays. It's time actually worked in excess of 40 hours in a 7-day work week. It also covers child labor. The basic rule on child labor is younger than age 14 children are not allowed to work unless they're working directly for their parents in a parent-owned company, and they can't do hazardous duties, and their hours are greatly restricted, especially during the school year. So we've got a detailed topic on child labor in our book, the Texas Guidebook for Employers. Equal pay refers to equal pay between men and women who are doing the same work at the same level of skill, experience, qualification, and responsibility. So if you have a man and a woman who are doing basically the same job, they've got the same years of experience, the same professional qualifications, the same duties, well, they need to be getting the same pay. If they are not being paid equally, that's potentially a gender discrimination issue. The state's main wage payment law is called the Texas Payday Law, and that's in our Texas Labor Code, Chapter 61. The Texas Workforce Commission enforces this law, which provides for several different things. Timely payment of wages, at least twice each month for non-exempt employees. That means employees who are entitled to be paid overtime. Salaried exempt employees can be paid once each month, but most companies go ahead and pay all of their employees on the same cycle. The Texas Payday Law also enforces the wage agreement. Whatever it says is what will be enforced as long as it's legal. Wage deductions are tightly controlled. Generally speaking, any wage deduction that is not ordered by a court or required by law needs to be authorized by the employee in writing. And in our book called Texas Guidebook for Employers, there is a sample wage deduction authorization agreement to illustrate what is meant by the written authorization requirement. The payday law also covers final pay. If somebody is laid off or fired, they need to be paid in full their final pay within 6 calendar days. If they quit, they can be paid on the next regularly scheduled payday. And finally, wage claims are handled by the Texas Workforce Commission. There are several things that these wage and hour laws do not do that a lot of people assume they do. For example, the law doesn't require breaks. Those are handled through company policy, and it's up to an employer to specify what breaks will be held, at what time, how long they'll be, where they may be taken, and so on. Premium pay is not required. The only premium pay is overtime pay at time and a half. Shift differentials, paying some people more than people who work on other shifts, that's not required under the law. That's a matter of the wage agreement. Raises are not required unless they have been promised in written form, in which case the written promise needs to be kept. Fringe benefits such as paid leave or paid holidays or severance pay, those are not required unless they're promised in a written policy or other form of agreement, in which case the written policy needs to be followed just like it is written. Pension benefits are not required. Expense reimbursements are not required unless failing to reimburse an employee's out-of-pocket business-related expenses would have the effect of taking their pay below minimum wage, in which case the employer would have to reimburse the expenses at least to bring them up to minimum wage. Because minimum wage is so important, it's very important to know what is legal to take from minimum wage. Payroll taxes, of course, can be taken. Taxes are always going to be legal. Court-ordered garnishment for child support, that's a legal wage deduction even below minimum wage. Other reasons why the pay may be reduced below minimum wage under the federal law are also listed here. But keep in mind, the Texas Payday Law is always in the background. It has to be followed as well. And under the Texas Payday Law, written authorization is needed for every one of the types of deductions shown on this screen, except for the top two. Payroll taxes don't have to be authorized in writing by the employee because the law requires them. Court-ordered garnishments do not have to be authorized in writing because a court has ordered them. But all of the others are merely permissible, and they have to be authorized by the employee in writing. Because overtime pay is so important, it's also very important to know what hours might count toward overtime pay. And basically, time worked is any time that the employee is at the company's disposal in such a way that they cannot use that time effectively for their own purposes. So a common example is on-call time. If they're on call, like on the weekends, if they can use the on-call time that they're not specifically on duty for their own purposes, such as sleeping or mowing their lawn or walking their dog, that's not work time. But if they're on call in such a way that they can't use that time for their purposes, then that is something that has to be counted toward hours worked for the week. Waiting time. If you told them to be at a certain place at a certain time, their clock begins as soon as they comply with your instruction. Breaks, ordinary coffee or rest breaks, they count as work time. Meal breaks do not count as work time as long as the employee is fully relieved of duty and they're able to eat a meal in peace without being disturbed by work-related matters. Sleeping time, that's primarily relevant for home care workers. That does not have to be paid as long as the employee is able to get at least 5 hours of uninterrupted sleep at a time, in which case you can exclude by written agreement the sleeping time and also, by the way, meal time, but that's only for duty shifts of 24 hours or longer. So this is really relevant for the home care industry. Preparatory and concluding activities, if they're an integral part of the job, those count as work time. Time spent in company meetings or company-related, job-related training programs, those count as work time. Travel time counts as work time if it's a direct, integral part of the job. Now, the normal commute at the beginning of the day and at the end of the day, that does not count as work time, but travel between job sites during the workday counts as work time. Keep in mind that time worked does not include paid leave. Paid leave might be paid under a fringe benefit policy, but it does not count as work time toward overtime if it's just paid leave or paid holidays. Voluntary overtime or unauthorized overtime usually has to be paid. There is no such thing as free overtime or working off the clock. The Department of Labor and the courts do not recognize that concept. If the employee worked the time, then the company got the benefit of it, and it has to pay for that benefit. Also, if somebody has clocked out but they're still working, tell them to clock back in, because the burden is on the employer to fully and accurately track all time actually worked by an employee. This rule applies even if the employee is working time that the employer does not particularly need or want or has authorized. They might even be violating a work time policy. But if the employer knows or should know that they're doing the work and they fail to prevent the work from being done, the employer has to pay for it. Count that as work time. Handle it as a disciplinary matter. It might be a rule violation, but it's not a pay issue. You have to pay for the time if it's worked. So be very careful about time worked. When you're calculating overtime pay, it's very easy if it's an hourly pay rate. You just pay for overtime at 1.5 times the regular hourly rate. It gets more complicated if you've got a non-exempt salaried employee. That means somebody whose primary duty does not exempt them from overtime pay, but they're still paid a salary. The overtime pay calculation is done according to how the salary is designed. So if the regular hours are less than 40, basically you divide the salary by the number of hours it's intended to compensate. That gives you the regular rate of pay. Then each hour up to 40 must be paid at that rate of pay if they work overtime, and then pay time and a half for hours over 40. That, by the way, you do this only for overtime work weeks. Don't do this if they work 36 hours. They get paid the salary for 36 hours. If they work 37 hours, they get paid the salary. But if they work 41 or 42 hours, then you would divide the salary by the number of hours the salary is intended to compensate. Let's say 36. That gives you the regular rate of pay. Then hours 37, 38, 39, and 40 would be compensated at that regular rate in addition to the salary, and you'd pay them at time and a half for hours 41 and 42. If their regular hours are supposed to be 40, then you divide the salary by 40 and pay time and a half based on that regular rate of pay for each hour over 40. If their regular hours exceed 40, then you pay the hours from 40 up to the regular schedule at halftime because the salary already compensates them at straight time for each hour over 40 up to the regular scheduled hours, let's say 45. But past the regular schedule of hours, let's say 45 in a week, each hour is paid at time and a half after that. It gets complicated. That's one reason why, as a general rule, we don't recommend paying salaries to non-exempt employees. It's just very, very, very complicated. Probably the most complicated computation is if somebody is paid a fixed salary for variable or irregular or fluctuating work weeks. In a case like that, the regular rate is calculated by dividing the salary by the total hours they work that work week. That gives you the regular rate of pay. Then you pay halftime for all hours over 40. That's because the fixed salary has already compensated them at straight time for all hours, including overtime. That means each overtime hour only needs to be paid at halftime based on the regular rate of pay. Other pay methods such as commission or daily rate or piece rate or job rate, task rate, book rate, flag rate, anything like that, it's much the same as the overtime calculation for irregular hours. You get the regular rate of pay by dividing their total straight time pay by the total hours worked. Then, because that total straight time pay already compensates them at straight time for each hour worked, you can bring the overtime hours up to time and a half by adding half of the regular rate for each overtime hour. That would give you the gross pay for the week, and that would properly pay them. All of this is explained in our book, in the article in part 2 of the book called Calculating Overtime Pay. The calculator is also included in the web app that we have. Exempt white-collar employees, those are the ones most people think of when they talk about exempt employees. There's 5 major categories of exempt white-collar employees: executive, administrative, professional, outside sales representatives, and computer professionals. Each one, except for outside sales, has a salary and a duties test. The minimum salary is now $684 per week. 10% of that can be commissions and non-discretionary bonuses. But the main problem for most of these exempt employee classifications is the duties test. The focus is on the primary duty. The primary duty is the main reason for the job to exist. The primary duty has to be exempt in nature. It has to be at an exempt level. And we're talking about the most senior, highest ranking employees in the company. For exempt salaried employees, their hours don't matter as much as the results that they achieve. Results matter, not specific amounts of time. You can't really standardize their work with respect to time. And again, exempt salaried employees are at the top levels of the company. Other employees look to them for leadership, and their decisions affect other employees and the company as a whole. The salary basis test, it's got to be at least $684 per week. There are minor exceptions allowed. If somebody misses a full day because of personal business, you can deduct a day's worth of pay from their salary if they don't have paid leave to cover that. If you have a sick leave pay policy in place, You can take a day's worth of pay out of their salary if they miss a day because of medical reasons. Then just make sure that you have that sick leave pay policy in place. It's okay to pay extra pay for extra work on any basis, including compensatory time, but that's only for salaried exempt employees. The executive exemption, those are executive employees. They make executive decisions, including hiring and firing, like the president of a company. Administrative exempt employees, these are at the top administrative levels of an organization, and they serve the company as a whole. They don't generally work with the employer's customers, but their work is related to the general business operations of the company, like the personnel director or a vice president of administration or a chief financial officer. Professional exempt employees in the learned professional exemption category, these are people who are have at least a 4-year college degree in the field in which they're working, and they're licensed or certified to do their jobs. Doctors, lawyers, teachers, engineers, architects, CPAs, scientists, and so on. These are the learned professionals. Creative professionals don't have to have a college degree, but they create original works of art or music or literature as a primary duty for their company. Outside sales representatives, just like the name implies, they don't work in the company's office. They're out, basically meeting with customers, trying to create new business opportunities, new revenue for the company. These salespeople can be paid on any basis. They don't have to be paid minimum wage or overtime, and the commission pay agreement counts for everything. So just make sure that you have a very clear wage agreement with those folks. Computer software professionals or computer employees, these are the top computer experts in the company. They design the company's computer network. They create computer software. They administer the company's network. Webmasters would be included as well. They can be paid either a salary of $6.84 per week or a straight time hourly rate of $27.63 per hour or more. If they're paid a straight time hourly rate, they don't have to be paid at time and a half for overtime, but each hour has to be compensated that way. Getting to the Texas payday law in the time remaining, the Texas payday law is our state's main wage payment law, and it's enforced by the Texas Workforce Commission. It applies to the private sector, but government employers, public employers, they're covered by similar laws. So all of this would be important information, even for public sector organizations. The main reason of the Texas payday law is to enforce the wage agreement. And what really counts is what was the wage agreement when the work was actually performed. That must be adhered to. It must be followed. Deductions are legal if they're ordered by a court, required or specifically authorized by a law, or if they're made for a lawful purpose and authorized in writing by the employee. Timely payment of wages due is required under the payday law, at least twice each month for non-exempt employees and once per month for exempt employees. And as far as final pay is concerned, keep that 6 calendar day deadline in mind for anybody laid off or fired. And if anybody quits, pay them by the next regularly scheduled payday. We have a sample wage deduction authorization form on our website in the Texas Guidebook for Employers. It's just a sample form. It's just meant to illustrate. It's not an official form, and you should have it reviewed by a wage and hour law professional before actually using it for your company. But if you have any specific questions, you're welcome to contact our office. Pay agreements are enforceable even if they're not in writing. So you want to make sure that pay agreements are as clear as possible. We recommend that they be in writing and signed by each employee. You can change the methods of pay and the rates of pay, but never in such a way that a retroactive pay cut results. because a retroactive pay cut always violates the law. What you see on the screen here are the legal methods of giving employees pay. Most companies do hand delivery or direct deposit, but you have to be careful to make sure that you do it by a documentable method and it's within the employee's agreement. With direct deposit, you need to make sure that there's no bank charges or fees that would take their pay below minimum wage. You also need to help employees get a bank account if they can't get one on their own because of like past credit history problems, because that's a problem under the EEOC. Also, keep in mind, federal law requires direct deposit to be at a bank that the employee agrees to. The same thing for payment by debit card. If you pay by debit card, you need the employee's consent concerning the card issuer. Plus, you need to give them written notice of how to opt out of payment by a debit card and alternative payment methods. Miscellaneous rules: if you pay wages in a form other than money, that needs to be authorized in writing by the employee. That's such as meals, lodging, and other facilities. Keep exact records on that. And remember, fringe benefits, paid leave, paid holidays, and severance pay, that's enforceable if it's in a written policy or agreement. Make sure that the policy or agreement is very clear. Paying on time, do your best to pay on time. There's no specific penalty for paying late, but eventually somebody will file a wage claim, and paying late is a technical violation of the law. Do not hold the paycheck pending submission of company timesheets unless there's no way to calculate the pay otherwise. If you have a way of figuring out the pay, you got to do it. Final pay, that includes all of the wages that they've earned in the final pay period. It does not necessarily include commissions, bonuses, and fringe benefit payments if those are governed by a different timeline in a specific contract or policy or agreement, like a commission pay agreement. Follow whatever the agreement says on that. If employees are not returning company property to the company, there might be a problem if you try to deduct that from their final pay. It might take them below minimum wage. You might want to take a look at the idea of a property return security deposit. That's in our free book, the Texas Guidebook for Employers, on our website at that link shown there. Finally, lower wage for final pay period. This is not particularly recommended, but if a company does it, it should really be part of the wage agreement itself, such as the final paragraph above the signature line by the employee. It should say something like, I understand and agree that my pay rate for the final pay period will be minimum wage unless I comply with the following conditions. Number one, return all company property in good shape minus normal wear and tear. Condition number two, I give at least 1 week's advance written notice of resignation if I resign. Condition three, I give my supervisor all my passwords to company files and folders and company computers, and any other conditions that you might think are appropriate. Okay, well, that's all we have time for today, but much, much more is covered in our Texas Guidebook for Employers on our website, and I would encourage employers to check out that book. All of the wage and hour topics are covered in part 2 of the book. And at this point, I'll turn it back over to the host, and our next speaker can begin with her topic.
Hello, hope everyone can hear me. My name is Valissa Chapa, and I am one of the other attorneys in Commissioner Aaron Demerson's office at the Texas Workforce Commission. I am going to share my screen now and put my presentation out for all of you to see. And a couple of housekeeping items first. So if you have a cell phone, you may want to show or to keep your cell phone out so that you can take pictures of relevant slides as it's going on. I think that is a wise thing to do. If there are links or phone numbers to relevant information, I want to make sure that you have that. So have your cell phone out. Also, I'm going over some basic medical leave related laws. I only have about 25 minutes. So I'm going to keep it brief, but I am going to throw in a little bit of changes some changes that have happened from COVID-19 into the presentation. So you'll get a little bit of both. So let's go ahead and get started. So here's the list of laws that folks want to think about when they're thinking of medical leave. There's a lot of concern from employers as far as what laws apply, what do we think about, how does this work? Here's your master list. This is what you can start with. And this is what we're going to be discussing today. The last bullet point, the Families First Coronavirus Response Act, that was passed in March of this year, signed into law. So that's brand new, and that has a few components. One of those is the Emergency Paid Sick Leave Act. That law is medical leave. It is included here, but it's going to be a very brief explanation because on October 1st, I'm going to go into a more detailed explanation of that law and the Emergency Family Medical Leave Act as well, that are both part of the FFCRA. So I'm including it here because it's relevant, but tune in October 1st for more information and more of an in-depth review of that law. So we're going to go ahead and start with just the basic interaction of these laws. The bottom line is, with all of these laws in place, some of them can apply all at once. So you have to make sure that you're fulfilling all of the coverage requirements for each law. And if there's multiple laws applying, generally the outcome that is more favorable to the employee is the safest bet. There is a little asterisk next to that because of COVID-19. There's a little bit of concern. So not always what the employee wants is going to be the way for the employer to move forward. And I'll go into that a little bit more when we talk about direct threat in the workplace. So here are the thresholds for coverage. All those laws at the beginning, they all apply to the employer depending on how many employees the company has. So if you have less than 15 employees, workers' compensation applies if you have workers' comp. If you have between 15 and 49 employees, workers' comp if you have it, and the Americans with Disabilities Act applies to your business. If you have 50 or more employees, or if you're a public agency, public and private, elementary or secondary school, you can have to deal with the Family Medical Leave Act, the Americans with Disabilities Act, and workers' comp. And finally, if you have under 500 employees and you're a certain public employer, the Families First Coronavirus Response Act could apply. So the point of this slide is to let you know that not all of these laws are going to apply to each company. It really depends on the size of the business. On top of that, each law has its own different time limit. So under workers' comp and the Americans with Disabilities Act, it's a case-by-case basis, so there is no time limit. And it'll make more sense as we go along as to why that is. The FMLA is 12 weeks per year. The FFCRA ends December 31st, 2020. So that is going to end at the end of this year, and that is, of course, 2 weeks or up to 80 hours of paid sick leave. So they all have different time limits. In addition, and I'm sorry, it seems like I have a little frozen screen here. There we go. Must the leave be paid? So question 1, does it apply to your business? Question 2, how long do these leave laws apply? Question 3, if you are giving them the leave, does it have to be paid? Here's the slide that tells you. The only law that requires leave to be paid is the last one, the Emergency Pandemic Sick Leave Act. That is only paid unless you meet an exemption, and I'll go into that on October 1st. But for the other laws, it can be paid or unpaid, so do keep that in mind. There's a lot of misconception. A lot of employers assume that the leave has to be paid, but it actually doesn't for those laws. So let's start with the Americans with Disabilities Act. Out of all the laws, this is probably the most complex, the heaviest one. So the majority of this presentation is going to focus on the ADA. So what is it? It's a federal law that basically says if you are an employer with 15 or more employees, you cannot discriminate against qualified individuals with disabilities. No discrimination, and you have to accommodate them. So here are the basics. The ADA applies during any part of the employment process, from the moment the application is sent out to the time you hire them and while they're working for you. So what happens with the Americans with Disabilities Act? You are required to reasonably accommodate employees who have disability accommodation requests. And it does not have to be related to the job. Many employers over the years have asked us, does the ADA apply if the employee, let's say, was working on an antenna on his home, off hours, non-work related, fell off, broke his legs, needs some accommodation, is he protected? Yes, he is. It does not matter where the injury occurred. It does not have to be work related. And that really makes sense because lots of folks have disabilities that they're born with. As we grow older, we get disabilities here and there. I've had several throughout my life, so it does happen. And that's why it's all encompassing in that sense. Now, so if you have to reasonably accommodate someone, what does that actually mean? So reasonable accommodation is anything you can change about the job without causing an undue hardship. So if you have 15 or more employees and an employee with a disability, then if they request an accommodation, you are required to reasonably accommodate unless there's an undue hardship. So we're going to go over all those components right now. So we'll start with the idea of what constitutes a disability. How does that all work? Well, the main point of this slide is to let you know that it can be physical or mental. It could be a physical disability or it could be a mental impairment, anxiety, OCD, PTSD. Those are covered as disabilities as long as the impairment substantially limits one or more major life activities. Major life activities, it's pretty basic, it's very broad. It could be sleeping, walking, breathing, all of those things, standing. Those are major life activities. So if someone has a physical or mental impairment that affects one of those activities, they have a disability. They could also have one if they have a record of impairment. And the last bullet point is a key one, if they are regarded as having an impairment. And what I mean by that is oftentimes you have employees who are pregnant or employees who you know have a condition, let's just say diabetes, for example. And many employers will assume that because they are pregnant or have this condition that they are automatically disabled and can't perform the normal functions of the job, and they sort of jump the gun. You want to avoid that. You never want to assume, because if you do, now they are included under this law. Now they do have a disability because you're treating them as if they have one. So does COVID-19 mean they have a disability? No, just because someone has COVID-19, that does not by itself mean they have a disability, okay? But it does mean that complications could arise from having COVID-19 and they could then have a disability. If they have an underlying medical condition that's exacerbated by COVID-19, they could now be protected. Or if the situation worsens and it's more than just a lost sense of smell or a sore throat, perhaps they're hospitalized, then it could turn into a disability. So that's how it's relevant to today's world. So you have an employee with a disability or a perceived disability, and they have issues at work. When is the ADA actually activated? When do you have to reasonably accommodate? Well, if you start treating them as if they have a disability, or the more common one is the second point. If the employee requests an accommodation, that activates the Americans with Disabilities Act. So what's an accommodation request? There are no magic words. It doesn't have to be, I'm invoking my rights under the Americans with Disabilities Act. They don't need to say that. They basically need to make you aware that they have an issue, a medical condition or disability that needs to be addressed so they can continue working. So no magic words, there's no official document they have to fill out. Companies can have their own documents for that, but they need to be very carefully crafted. So I would recommend to have an employment law attorney draft one. But even then, they don't have to use that document to make an official request. It's very expansive. It also makes sense that family members can request an accommodation on the employee's behalf. Happens often when someone is hospitalized. A spouse, a friend will call the employer and update them. That is a request that activates the request to reasonably accommodate someone under the ADA. So now you have an employee with a disability. They've asked for an accommodation. What is a reasonable accommodation? Luckily, the law is very reasonable with that definition. it is required by law to reasonably accommodate, first of all. You have basically no choice as an employer. If someone requests one, you have to attempt to do so. And it doesn't matter if the employee is part-time or full-time or probationary. There's 3 categories of reasonable accommodation, which is pretty basic. Modifying the job application process, modifying the work environment, a standing desk, for example, or modifying the work environment and adjustments to policies and procedures, things that will allow all of your employees to equally enjoy the benefits and privileges of employment. So a lot of it, most accommodations are inexpensive, less than $500. For me, my standing desk, I had a bunch of binders stacked up, and I had my workmates help switch me out when I was sitting and standing. So there's a lot of creative solutions to reasonable accommodation, and you should be creative. What's not reasonable? Eliminating an essential function, lowering production standards, or providing items that someone would need to accomplish daily activities like eyeglasses or hearing aids. Those are things that could benefit them at the office, but those are also things that they would need to use in their day-to-day life activities. So those items the employer is not required to provide to their employees. Examples of reasonable accommodation: we have teleworking, super hot right now with COVID-19, making sure the facilities are accessible, restructuring. The last bullet point is actually the one I wanted to highlight: reassignment to a vacant position. Sometimes you're trying to accommodate someone, figure out what they can do. It's going to take some time. And if they can't do the job you hired them to do until you figure those things out, see if there's a vacant position that's available to them that they can do with their skill set. And side note, if you offer that to them, the rate of pay for that position can be the rate of pay that you offer for that employee to work that position until you can work out an accommodation. Now, direct threat under the ADA. What is this all about? So this is the idea that someone poses a direct threat to the business, and you can try to reasonably accommodate them, and maybe you can substantially reduce the harm, but you can't eliminate it altogether, and there's a lot of concerns. The employee might feel disgruntled, might feel that they are being retaliated against or discriminated against because of their issue. And this slide is to sort of explain how this relates to COVID-19. So if an individual poses a direct threat to the business and there's no reasonable accommodation can eliminate the threat, they are not protected by the non-discrimination laws. Basically, COVID-19, according to the CDC, is a direct threat, according to the CDC. So what does that mean? By having someone with COVID-19 or symptoms of it present in the workplace, they're a direct threat. You can send them home. Now, the CDC can revise its guidance as things happen, but as of this moment, as of today, September 17th, 2020, the CDC is considering COVID-19 to be a direct threat, which means send them home. And earlier when I talked about employees being treated more favorably under the law, this might be an example where an employee wants to come into the office, wants to work, perhaps their symptoms are mild and they don't see an issue with it, but they pose a direct threat. In that case, you wouldn't be giving the employee what they wanted. You'd be sending them home. And of course, working from home, if that's an option, is something the employer should explore. Now, here's a question from the EEOC, and I'm not going to read it out. I have it here to point out that there's a lot of good guidance online, but what are some accommodation ideas where you're looking at someone with a direct threat? What are some things you can do? You can erect a barrier, increase the space. You can even eliminate some marginal functions. Also, creative solutions, modifying their work schedules to see if they can go somewhere else, moving the location of where they work, more social distancing. So those are just some options to consider when we're talking about direct threat. Another issue with COVID-19 is, what if you have someone with a pre-existing condition that was exacerbated by the pandemic? Specifically, what if you have someone with anxiety, OCD, PTSD, and the COVID-19 environment has exacerbated their conditions? Are they still protected under the law? Arguably, yes. But as an employer, you have the right to ask questions to determine whether their condition is a disability, talk to them about possible accommodations, explore alternatives, and request medical documentation. And that all has to do with this slide, the interactive process and the ADA. So again, from the beginning, you have an employee with a disability. They've let you know they need an accommodation. You're going to try to reasonably accommodate it, How do you do it? Well, reasonably, you talk to them. You try to figure out what the options are back and forth. That's the interactive process. That's what it is. It's just talking, but it's mandatory and it's crucial. So you have to do this process. It allows you to identify barriers to performance. You can look at all the options for the accommodations. It also is really important to show that as an employer, you're following the procedures and help and as required. In case something goes south, you want to have your ducks in a row. Following this process and documenting everything and keeping it confidential serves to protect you in the event that the employee states that you did not go above and beyond, you did not try to help them. So always document, always keep it confidential. Also, this interactive process helps you to determine whether or not there's an undue hardship. So when is accommodation not required? If they're no longer qualified for the position. And an example would be a truck driver who was hired to drive long distances, has a back injury, can no longer work. In that situation, the employee may not be qualified for the position because they can no longer drive long distances. So that's when your accommodation requirements may end. Or it would cause an undue hardship to the business. And undue hardship is a very high bar to meet. It means significant difficulty or expense. So for undue hardship, everything counts. Financial difficulty, the disruption to the workplace, business operations, it all counts when you're looking at whether or not an accommodation is an undue hardship. But don't assume that hardship equals undue hardship. There's a lot of employers who know that it's difficult, but they assume that because it's difficult, that's enough. No, the bar for undue hardship is actually very high. And of course, documenting all of this is how you protect yourself if you reach the conclusion that you can't accommodate. Undue hardship is your argument. That's where the interactive process from before becomes so important, because it shows that at the end of the day, there wasn't anything that you can do to get away from the undue hardship. You considered every possibility. And don't forget, it's also analyzed on a case-by-case basis. So when you put all of this together, if someone has a disability, talk to them, keep it confidential and private, work with them, look at all creative solutions. Whatever solution they have is not necessarily the one you have to go with. If they're demanding a $3,000 standing desk, but you can resolve that for free or for much less, you don't have to go with the most expensive option just because that's what the employee wants. Again, it's all about what is reasonable. Now let's talk about doctor's notes. Can you ask for a doctor's note? Yes, you can. Here's what you don't want to do. You do not want to inquire about diagnosis or prognosis. You cannot do that generally. It is not allowed. And the reasoning is, as an employer, you don't need to know those things. You don't need to know if someone is a diabetic, how the condition is progressing. That is not business related. What you need to know is when the employee is going to be there to work, what accommodations they might need, all of that to keep the trains running on time. So don't inquire about those things. However, there's a bit of a change. When we're talking about COVID-19, according to the EEOC, you can ask employees if they have symptoms of the virus. Now with doctor's notes, of course, you want to give them a reasonable deadline to give you the note. You want to give them a job description to give to the doctor, so the doctor knows exactly what they're doing for their job. A bit on the bottom right-hand corner, COVID-19 update. Can you ask for a fitness for duty document? Yes, you can, but the key is you want to make sure that you are aware of the fact that medical professionals today may not have all of the time that they used to give the traditional note. So nowadays, acceptable alternatives can include forms from local clinics, stamps, and even emails to certify a negative COVID test. So do keep that in mind when asking for medical documentation. Also, make sure that you don't just consider full release. This is because under the Americans with Disabilities Act, you have to reasonably accommodate someone. So you don't want to take it too far. If someone can work in the office with some restrictions, work with that. So that's what you ask for. A lot of employers will say, let us know when you're released to full duty. Do not do that. You need to also entertain the idea of modified restrictions. What if they can come back on a reduced schedule or have some restrictions for lifting, bending, and stooping? You know, you want to know what are those restrictions and how long are those going to last so that you can make adjustments in the office. So ADA and COVID-19, here are some FAQs. And the first one from the EEOC is, what can you ask for if someone says that they are sick and they call in? Typically, you cannot ask them what symptoms they have, but because of COVID-19, during this time, you can ask if they have specific COVID-19 symptoms: fever, chills, cough, shortness of breath, or sore throat. Also, do you have to require or can you allow employees to stay home if they have symptoms of COVID-19? Yes, you can. So for more information, I really wanted you to know about these two articles. If you have your phone out, now's a good time to take a picture. Really great articles here about the Americans with Disabilities Act, Rehabilitation Act, and other laws. These are from the EEOC. Excellent resources, and a lot of the Q&A that I put in here are from these resources. So please do keep these articles in mind. Really, really good stuff. Also, here are some strategies for COVID-19. The first one, the Job Accommodation Network, it is a free resource. I cannot say enough good things about the Job Accommodation Network. What is it? They are funded by the Department of Labor, and the folks at JAN assist with the Americans with Disabilities Act and accommodations. You can contact them for assistance. It is free, it's confidential, and they are there to help you. There's also Earn, another free resource, and that is for helping to recruit, hire, and retain qualified employees with disabilities. So lots of good stuff there for you as well. Now, some basics on the FMLA, the next law. And I have a few minutes left, but I'm actually just going to touch little bits for the rest of these. So the Family Medical Leave Act, what is it? It allows up to 12 weeks of leave, of unpaid leave, per year for the following issues. And remember, for birth or adoption of a child, that includes new fathers and new mothers. So also remember, for FMLA, birth or adoption of a child applies to both. You get up to 12 weeks of leave. So it applies to employers with 50 or more employees, like I stated. So it applies to the company if you have 50 plus employees. But then the question is, does it apply to the employee? The employee had to have worked at least 1,250 hours in the last 12 months to qualify for FMLA. So even if you're covered by FMLA, if you have a new employee who's been there for 2 months, they may not be eligible. They would not be eligible for FMLA. But don't forget, they could qualify for reasonable accommodation under the ADA. It doesn't matter. They can work for you for 1 minute and be qualified, but they would not be eligible for FMLA leave. And this chart, or this slide, breaks down why it's so important, the difference between the two. I have this here just as a warning for folks. It's very common for an employer to give someone their 12 weeks of FMLA leave. And then when they're not ready to come back, let's say that it was an employee who gave birth and she's having some significant complications from the pregnancy that she's still recovering from. And after the 12 weeks, she's still not recovered. A lot of employers will say, well, you're done with FMLA. We're going to go ahead and let you go. Time's up. Do not do that, because the employee is still arguably covered under the Americans with Disabilities Act, which of course means reasonable accommodation, and there is no time limit. So I really wanted to highlight that between the two. Also, for FMLA, never allow an employee to work from home while on FMLA. The Family Medical Leave Act does not allow it. That's why the word leave is in the title. They cannot work while they're out on FMLA leave. So prohibited actions, never count FMLA leave against employees, never fail to allow them leave, and never retaliate. And also don't let them work from home. A lot of it is common sense, but it is good to have reminders. I really wanted to highlight this first link, the Employer's Guide to the Family and Medical Leave Act. This is an excellent source. If the FMLA applies to your business, you need this. This is made by the Department of Labor, extremely handy piece of information on here. And I'm just going to go quick to show you something fabulous. They have this roadmap to the FMLA. From start to finish, you have your support. And let's say you're at step number 6, you need certification. Click on the word and it takes you to that piece. And this also has links to the actual laws themselves if you want to take a look at them. But this is a fabulous source. Again, it's the Employer's Guide to the Family Medical Leave Act. Maybe take a picture of this slide. That source is wonderful. Department of Labor also has a fact sheet number 28, and you can call them with questions if you have those as well. So the Pregnancy Discrimination Act, this applies if you have 15 or more employees. And what does it basically mean? Do not assume that an employee cannot do something just because she's pregnant. You don't want to jump the gun or go beyond what you need to do. You want to treat such employees the same way as you would with any other disabled employee, period. So there's a lot of concern from employers during the pandemic that they have pregnant employees and the employers want to take initiative and send them home now just because they're pregnant. Can you do that? No, you cannot. Sex discrimination under Title VII of the Civil Rights Act includes discrimination based on pregnancy. So even though you're coming from a good place, you can't single someone out just because they're pregnant and send them home. That could lead to a violation of this law. Also, just remember, pregnancy is not a per se disability. What I mean by that is just because someone is pregnant does not mean they have a disability. But of course, they can need reasonable accommodations during and after the pregnancy. We all know that. So remember as well that even if they go out on FMLA leave and they've exhausted that leave, if they still need accommodation, you are required to provide it. Workers' compensation, just the basics. I think we're going to be covering this as well in a future seminar in the coming months. But what it is it's income replacement. This is for job-related injuries. You cannot retaliate against an employee, and there are statutory caps on compensation for covered medical conditions. So Texas is the only state in the United States that doesn't require workers' compensation, but it does cover job-related injuries and illnesses. And so with that, it covers employees of the company. Here's where you want to be careful. It can also cover borrowed servants. So if you are a company that hires an independent contractor to come in and do a job, and that independent contractor has his or her own team of folks to help out, if you start controlling those employees or workers of your independent contractor, they have now become your borrowed servant, and they are now covered under workers' comp. So you do want to be careful about that. So what not to do for workers' compensation, obviously don't ignore workplace conditions that are unsafe, never interfere with an employee's right to file a workers' comp claim, never retaliate, and also don't assume you understand the injury. Back injury can be different for different people. Best practices, of course, follow your OSHA guidelines, have a return to work policy. Please train your employees on best practices. And also, you might want to take a picture of this slide. Call the Texas Department of Insurance, their Division of Workers' Comp, or you can ask your carrier for assistance. But TDI heads up workers' comp, and they have lots of good information for you. So again, you're not alone. So how does workers' comp work with COVID-19? Well, it might be covered under a workers' comp claim as an occupational disease. Admittedly, it's hard for folks to prove that they contracted COVID-19 at the workplace as opposed to in other places, but regardless, don't make that decision. Report it to the workers' comp carrier and let them investigate. Now, this is the last slide for the leave-related laws. This is the Families First Coronavirus Response Act, which includes the Emergency Paid Sick Leave Act. This was a new law that was just passed back in March. It ends in December, and it requires you to pay up to 80 hours of paid sick leave if one of these 6 conditions are met. Number 2, for example, if a healthcare provider told someone to self-quarantine because of COVID-19 exposure, they meet one of the requirements to get up to 80 hours of paid sick leave under the EPSLA. Department of Labor administers and enforces this law. So if you have questions, please don't hesitate to contact your Department of Labor office. They're giving a lot of really good guidance on whether or not these laws apply. And also tune in for our next session on October 1st for more information. Also, you might want to take a picture of this, helpful resources, the Job Accommodation Network for the ADA, also the EEOC. If you want to know where to go for your final facts, your sources, there's a lot of information out there. This slide is showing you the main authorities on these issues that you can go on their websites and look at it. To keep it clean and organized and go straight to the source, this might be a great slide for you. So that was it for my presentation today. I am now going to turn it back over to Tommy Simmons. He's going to speak for just a few moments about Payroll Tax 101 before we head into Q&A. Back to you, Tommy.
Okay, thank you very much, Melissa. And hopefully everybody can see my screen. This is a brief presentation on payroll tax. I call it Payroll Tax 101, and it's just the basics. But I'm going to have a few comments about payroll taxes, mainly focusing on the state unemployment tax. So hopefully everybody can see me okay there, see the slides. And again, the contact information for Commissioner Demerson's office. Oh, just a minute. I got to note that the slides are not visible. Just a moment. Okay. Okay, are they visible now?
Yes.
Okay, very good. Please excuse that. That's me fumbling around with Microsoft Teams. Okay, so back to this. Let me put it once again in presentation mode. Okay, the main thing to remember about payroll taxes are owed on wages. And wages, of course, are compensation for personal services rendered. There are some things that don't count as wages, don't have to be reported. Those are few and far between, though, and you want to be very, very careful. If you have any doubts about that, consult a CPA or a tax attorney or call Commissioner Demerson's toll-free number, and we'll be glad to talk with you about it. The main federal payroll taxes are the withholding tax, FICA and Medicare tax, and the federal unemployment tax. In Texas, we have the state unemployment tax. But a few comments, though, before we talk about anything else. Probably the most important document to get filled out and completed and in hand before you let a new employee work is a W-4, a W-4 form. An employer has a full legal right to require an employee to submit a properly completed W-4. Do that before you let the employee do any work at all, because it gives you everything that you need to know to properly report the employee's wages and pay payroll taxes to the IRS and the TWC. If you let employees work before they complete a W-4, there might be problems if they just suddenly disappear. They ghost the company or they quit without notice. What are you going to do when it comes to their final paycheck? That it becomes problematic. There are ways to deal with it, but all of those ways involve spending time on the phone with the friendly staff in the tax departments of the IRS and the TWC. And many people would not consider that to be a lot of fun. So get the W-4 before you let the employee do any work at all. The best sources for information on federal payroll taxes is found in certain IRS publications, and here's the top ones. These are the ones that I would recommend for any employer. Publication 15, that's basic withholding tables and other information. Publication 15A is details about payroll taxes and exemptions, and publication 15B helps employers understand about taxation of fringe benefits. So download those publications. The IRS can assist you. It can be tricky, though, during the pandemic with office closures and lots of phone calls coming in about lots of different tax programs to get a hold of them. But your best chance is to call the local IRS office in your area. I've got the web address for the nationwide directory of IRS offices there. It's indexed by zip code. If you want to call the National IRS office, they've got a toll-free number that you can call. But again, they have a warning on their website that it can be quite a long wait before somebody picks up on the phone. So an alternative would be if you have a CPA already or a tax attorney, you can consult with them, or you can utilize any good modern payroll accounting software. They all have the payroll taxes programmed into them. The federal unemployment tax, that's relevant for this agency. The federal unemployment tax rate is 6%. It's applied to the first $7,000 of an employee's wages in a calendar year. The tax rate, though, is actually, for most employers, 0.6%, 1/10 of that. In other words, a 90% discount off of the regular unemployment tax for employers that operate in a state like Texas that has a federally compliant unemployment system and who pay their state unemployment taxes properly. The main problem with not paying your state unemployment taxes to the TWC is that you don't get to use the 0.6% federal tax rate when you pay taxes to the IRS. You would have to use the 6% tax rate. That is basically a 900% increase in taxes payable. Don't let that happen to you. The state unemployment tax, of course, is the only payroll tax in Texas. It's paid by employers. Employees do not pay the state unemployment tax. That's a big misconception. There is no deduction allowed, in fact, from employees' wages for the state unemployment tax. It's a tax imposed on employers, paid by employers, solely out of employer proceeds, employer funds. The tax rate is based on the unemployment claim experience of a particular employer. The unemployment tax rates in Texas, they are basically hardwired into the Texas Unemployment Compensation Act to a very large extent. New employers pay at the new employer tax rate of 2.70% for the first 6 calendar quarters that they're in operation. After that, they're eligible for an experience rating to have a calculated tax rate. Employers that don't have any chargebacks during the preceding 3 years get the minimum tax rate, which is equal to the replenishment tax plus the 0.1% ETIA rate. Employers with chargebacks during the past 3 years will have a calculated tax rate based on chargebacks that they've had from unemployment claims during the preceding 3 years. When the TWC calculates an employer's unemployment tax rate, the central component, the central factor in the tax rate is the benefit ratio. The benefit ratio is calculated by taking the total chargebacks over the past 3 years and dividing that by the 3-year taxable wage total. So basically the 3-year chargeback total divided by the 3-year taxable wage total yields the benefit ratio, and that's the main component of the state unemployment tax rate in Texas. If you have a high chargeback total, that's going to lead to a higher benefit ratio and ultimately a higher state unemployment tax rate. If you have a lower chargeback total, that's going to result in a lower benefit ratio and lower unemployment tax rates for your company. Only the wages on which unemployment taxes have been paid to TWC can be included in that benefit ratio calculation. So there's a big incentive to pay the UI taxes properly. If you pay the state unemployment tax, then not only do you get the 90% discount off the federal unemployment tax, you also make sure that all of the wages that you have paid to employees are taken into account in the tax rate calculation for Texas. Now, to get into a little bit of detail about the state unemployment tax rate calculation, it is complicated. The formula is built into the Texas Unemployment Compensation Act. The TWC must follow that formula. I've got it programmed into the estimate chargebacks and tax rates utility in the online version of our Texas Guidebook for Employers. Anybody who's interested is welcome to see the formula behind it. But basically, you take the benefit ratio and you multiply that by the replenishment ratio to get the general tax rate. The general tax rate is modified with some adjustments to it. First, the replenishment tax is added to it. The replenishment tax is the only tax that employers without chargebacks have, but for employers with chargebacks during the past 3 years, you're going to have the general tax rate added to the replenishment tax. There might be a deficit tax if there is a deficit in the state unemployment trust fund. There might be a surplus credit if the trust fund balance exceeds the statutory ceiling. That's actually happened a few times in the past few decades. It's not common, but it sometimes happens. There might be an interest tax if Texas owes interest on a federal unemployment loan. Right now, I'm sure that this will be of interest for the audience. We have interest-free loans coming from the U.S. Department of Labor on unemployment insurance. So there is most likely not going to be any kind of interest tax to worry about for the next for the upcoming future. Also, there might be an obligation assessment tax if Texas issues bonds to pay unemployment benefits and we need to repay the bonds. That is done with an obligation assessment taxes. The effective unemployment tax rate, which is the bottom line tax rate that you apply to the first $9,000 of each employee's earnings in a calendar year, that is the result of all of those factors taken together. And all of those factors are programmed into the online version of the book. Now, if there's a shortfall in the Unemployment Insurance Trust Fund, it's recovered through a mechanism that is, basically provided for in the Texas Unemployment Compensation Act. Half of the shortfall is recovered through the replenishment tax. That's paid by all private taxed employers. The other half is recovered through the replenishment ratio, which, remember, the replenishment ratio applies to employers that have chargebacks over the past 3 years. The replenishment ratio is multiplied by the benefit ratio to get the general tax. Okay, the tax rate calculation formula is illustrated in very nice detail at the tax department website. I've got the link shown on the screen there. And there is a chart of historical tax rates going all the way back to 2011 on the next page that is shown in that link at the bottom of the page. So you can find that. Just click on the TWC website under employer information, learn about taxes, learn about how the tax rate is calculated is what brings you to that link on the TWC website. New unemployment tax rates for the next year, for 2021, are published according to a schedule. Basically, the look-back period, it's a 3-year look-back period that the TWC uses. That's the 3-year chargeable chargeback total divided by the 3-year taxable wage total. That look-back period ends on September 30th of each year. In October, the tax department takes all of that information, the wage and chargeback information that it needs for the calculations. In November, the calculations are carried out, and the tax department shares the aggregate information with the commissioners. After the first week of December, usually after December 7th, the tax rate notices are mailed out to private taxed employers. Those are the C-22 forms. And every employer should get a copy of that form mailed to their tax address of record. So that's a good reason to make sure that the TWC always has your current valid mailing address. And by the way, that is a requirement under TWC regulations. If an employer wants to appeal its tax rate or any decision of the tax department, such as decisions about the employment status of workers or what effect a business acquisition might have on the employer's tax rate or other tax issues, that can be done by appealing to the Commission via Commission Rule 815.113. There's a really good explanation of the so-called Rule 13 appeal process at the link that is shown in that middle bullet point. And if you file a Rule 13 appeal, the commissioners themselves will make the final decision on that. They will meet in a public meeting and they will vote on the outcome of that appeal. All right, so that's all that we have time for on payroll tax, but here is the contact information for Commissioner Demerson's office, and we will be happy to entertain any questions that y'all may send via email or call in with using those phone numbers down below. And at this point, I'll turn it over to the meeting back over to the host and let any supplementary information begin. Let me stop sharing my screen right quick. There, stop sharing.
Good. And so, Tommy, thank you so much, you and Melissa, for the presentations. And if there are any technical difficulties, we'll have this recorded live as well. This is, I mentioned this is the first of 7 sessions that we're hosting right now. And I know there have been questions submitted previously, and the attorneys have answered those questions. And so we're going to make sure that we get those out to you. We do have 10 minutes. And so if there are any questions that you guys have, we can pop into some of those, and or we can allow our conference attendees to move on with their day from that standpoint. And so if you were planning on answering any questions, then you guys can go ahead and do that. And if not, we're going to move on. So I'll await your direction in regards to answering any questions that they may have submitted.
Thank you, Commissioner. We actually do have an amount of questions that were received. Tommy has put many of the responses to those in a wonderful document that's searchable, and we will be making that available to attendees. But we also have some questions that are relevant to today's discussion. So Tommy and I are going to spend the remainder of this conference time answering those questions. And just to keep it clean, I think I'll go through the ones that I have first, and then Tommy can answer the questions that are related to his presentation. So one of the first questions that I received had to do with an employee who was continuously absent because he's providing transportation for his wife who is ill and needs to go to medical treatment a few times a week, and he takes her to doctor's visits, so on and so forth. The employer wants to know, would we be able to terminate this employee without breaking any laws? Because of COVID-19, we have a skeleton crew, and it's become more difficult to be flexible with him. And this is causing a burden on the workplace. How do you proceed? Well, first of all, you look at the relationship. It looks like this employee is absent because he is providing transportation to important doctor's visits for his spouse. So under the Americans with Disabilities Act, that applies to an employee's own disability. It does not extend to family members. So there is no coverage under the Americans with Disabilities Act for that individual. However, if you are an employer with 50 or more employees and you're a private employer, then the Family Medical Leave Act, the FMLA, might apply here. And so that all depends on whether you have 50 or more employees. It depends on whether the employee worked the last 12 months, 1,250 hours. And if so, the reason for why he's taking his spouse to those visits might be covered under the intermittent leave laws under the FMLA. So if you have 50 or more employees and you're in that position, the FMLA would be the law that could apply to that scenario. So you definitely want to double check on that and see if this is an FMLA qualifying event. And if so, follow the steps. And again, the Department of Labor's Employer's Guide to the FMLA is an excellent resource to help get you started with that. If the FMLA does not apply, then there is no law, to my understanding, that would control what the employer must do in that situation. The next question comes from an employer who has an hourly employee, and this employer says the hourly employee has been with the company for less than a year and recently had a back injury, and she does a physical job for the employer and she can't work. This employee does not qualify for FMLA leave based on the time on the job. She hasn't been there for a year. So at this point, the employer is unsure how long she will be out. She does great work and they want her back. So what can they do in the meantime? Is there medical leave they can offer? Well, as a starting point, if that company has 15 or more employees, this employee could be protected under the Americans with Disabilities Act, which would mean that you'd have to reasonably accommodate the employee. And as we discussed earlier, reasonable accommodation can mean a lot of things. It can mean modifying their job environment so they can continue working, or it could also mean job protected leave until they can come back and work on maybe some light duty or full release. So if this business has 15 or more employees, then the Americans with Disabilities Act applies and you are required to reasonably accommodate. At this time, it would be job protected leave. So you'd want to avoid any language as far as we're going to temporarily lay you off or furlough. You want to avoid all language that makes it sound like she's being separated from employment. Instead, it's more like you are going to offer her job protected leave. So that's what I think you must do in the interim, and talk with her, document, of course, keep that confidential, need to know people only in the business. And the other part of that question was, is there medical leave you can offer where she can pay for her medical? So that's a really good question. Under the ADA, pay does not have to, or leave does not have to be paid, but you can pay them if you want. That's the employer's choice, but remember, you must treat all employees the same under the law. So if you do decide to pay her for that time out, you need to remember that you're setting a precedent for future employees in future scenarios. The other issue is documenting everything for that, I think, is important. Also, medical. If they have health insurance with the company, whatever you agreed to initially is what you're still obligated to pay. A lot of companies will do a 70-30 split on health insurance, or a 50-50. You pay 70%, the employee pays 30. When someone is out on medical leave, even if it's unpaid, you're only required to pay that 70% you agreed to initially. Can you kick in the other 30? Yes, you can. But just remember, you're setting a precedent for other employees as well. And the next question we received is, if an employer previously approved an accommodation for an employee to work from home because they were in a high-risk category for contracting COVID-19, the employer wants to make alternative arrangements so that the employee can return to work on site. What is the recommended process? Well, in my opinion, it all starts with making sure that if you're going to consider that you are eliminating any possibility that that employee would be exposed to COVID-19 at the workplace, of course, because there's liability issues there, and you certainly don't want this person to get sick. You want to make sure they're okay. So if you make that move, you want to be extremely cautious. You want to make sure you're eliminating all risks. And also you want to engage in that interactive process where you're talking to the employee about what you'd like to do. This is where we'd like to go with it. What are your thoughts? Let's talk about their concerns, your concerns, and try to meet them in the middle. And ultimately, just remember, is that really worth it? If they're still producing well from home and there's a little bit of risk that you would incur by bringing them back, is it worth the risk? So I think thinking about that heavily before you move forward is important, and also just talking to the employee and letting them know about it. So those are the basic questions I received. I did get one more simple one. According to the Emergency Family Medical Leave Expansion Act, that's a new law that was passed in February, where if someone doesn't have childcare, you have to pay them 10 weeks of leave. This employer wants to know, does this pertain to employers with 500 or more employees? No, it does not. It applies if you have under 500. And the other question was, if they're staying home to attend virtual school, does that mean the school is still closed? According to the guidance I received from the Department of Labor, yes. Even if they're open in the sense that they're doing virtual learning at home, because the physical building is still closed, the school is still closed for the purposes of that law. So those are all the questions I had related to my issues, and with the time remaining, I will turn it back over to Tommy.
Thank you very much, Melissa. I have time to cover a few of these questions that were submitted, and the rest of them are covered in that FAQ document that Commissioner Demerson mentioned earlier would be made available. Here's an interesting one. How many hours Does an employee have to work before taking lunch? The answer that I would give is, since lunch breaks are optional under Texas law, the lunch break schedule would be determined by the company. You don't have to have lunch breaks. Most companies observe some kind of lunch break, but that's a matter of scheduling, and it depends upon the convenience of the company, basically. So regulate that with the schedule done by the manager for the employees. Another interesting question. Currently, we pay overtime if our field technicians work more than 40 hours a week, regardless if it's a short week. We've implemented weekend on-call rotations. If the employee does not work 40 hours and it's his turn to be on call on the weekend, should we be paying overtime on the weekend? What I would say to that is overtime pay doesn't depend upon when the work occurs, unless the wage agreement specifies that extra pay will be given for working at night or on weekends or on holidays, in which case you'd follow the wage agreement. The federal law requires overtime pay only on time actually worked in excess of 40 hours in a 7-day work week. So my suggestion would be keep it simple. The simpler you keep it, the less chance there is that mistakes will come in there. Here's another question. The interplay between Department of Labor extended or expanded FMLA and IRS rules is confusing regarding children under age 18 versus IRS children under 14. Any help you can give would be great. Thank you. I would refer that company to the Department of Labor definition of son or daughter under the Expanded Family Medical Leave Act. That's explained in the Department of Labor FFCRA frequently asked questions file on their website, which is excellent for IRS purposes. Look on their website. They've got a link on their COVID-19 tax credit page for determining the amount of the tax credit for qualified family leave wages. And so just take a look at the IRS website. The exact link is given in the frequently asked questions document that Commissioner Demerson referred to. Another question, what are the payroll tax cuts for COVID? Are those optional to implement? And that's a very, very complex issue. The temporary extension of due dates for Social Security taxes that was included in a recent presidential order. Very, very complex issue. The IRS will regulate that. They have guidance on their website, which you can find by going to the IRS website at irs.gov. Another very timely question. How do I terminate a work-at-home employee and recover company property? Well, exactly how you terminate their employment is up to the company because Texas law does not really regulate that. But no matter how you do it, you want to make sure that you do it in a documentable way because you want to be able to prove that the employee was effectively advised of the ending date of their work. And that's to forestall the possibility of somebody claiming that they did more work than the company planned to give them. And how you recover company property, that usually requires a mutual agreement, preferably worked out before the need arises, signed by the employee and by a company representative. Look in our book for suggestions on that. Another question, can a minor work on a mobile vet unit or an ambulance? What I would say is yes, as long as the minor does not drive the vehicle or become exposed to radiation or hazardous substances. The Texas Child Labor Law poster is an optional poster on our website that has a complete list of prohibited hazardous duty occupations for children. Unfortunately, it looks like we may have reached the end of our time, and out of respect for everybody's busy work schedules out there in the business community, I'm going to go ahead and end with that and turn it over to Commissioner Demerson for any closing remarks that he may have.
All right. So Tommy, once again, thank you and Melissa for all of you. The information you provided has been very valuable and relevant information. As I mentioned, this is the first of 7 that we have here, and we'll make sure that we're fine tuning and being in a position to get the best information to our Texas employers. And so once again, thank you guys for joining us. Kim, thank you for the work that you've done to put this together. We have in the batter's box Elsa Ramos and Mario Hernandez to come up as well at some particular point. And so we're excited about what they're going to be bringing as well. Thank you guys for all that you do. We don't take your investment in our state for granted. And we look forward to seeing you on the next Lunchtime Live virtual session. Thank you so much. Have a good day.